If someone refuses to answer questions, won't attend meetings, or simply disengages from professionals, does that automatically mean that they lack mental capacity? Well, it's a really common assumption and actually a really, really dangerous one. Today, I want to unpack why a lack of engagement does not automatically equal a lack of capacity. We'll look at what the Mental Capacity Act actually requires of us, as well as how the courts have helped us draw the distinction more clearly. So, what do we mean by the term engagement? Well, in the context of mental capacity assessments, engagement simply means actively participating in the process. That might include answering questions, it might mean attending appointments, or it could just be communicating their views in any form. A lack of engagement then is when the person doesn't, for want of a better word, cooperate, right? They may refuse, they may withdraw, they may stay silent. But here's the key question we must ask ourselves. Is this a capacitous choice not to engage, or an inability to engage because of an impairment of the mind or the brain? So, how does the first principle of the MCA help us with this? Well, the Mental Capacity Act 2005 starts with a very strong position. It tells us that every adult is presumed to have capacity unless it's proven otherwise. And this means that the burden sits firmly with us as assessors or professionals, not with the person being assessed. In essence, the person being assessed has nothing to prove. They're entitled to say no. They're entitled to disengage. And you know what? They're entitled to refuse an assessment altogether. Non-cooperation alone is not an evidence of incapacity. So let's look at this capacitous refusal versus an inability to engage, because this is where things get really nuanced. Because sometimes a person chooses not to engage, and that choice itself may be capacitous. In Re QJ 2020, the court warned against assuming that reluctance or selective answering automatically reflects incapacity. The evidence suggested that QJ understood what was happening and was making a conscious decision about how much to engage. Now we contrast that with cases where non-engagement genuinely stems from incapacity. In Nottingham NHS Trust versus RL in 2023, RL was mute, withdrawn, and demonstrated an inability to link treatment with survival. The court accepted that his lack of engagement was not a choice, but a manifestation of a serious mental disorder. Same behaviour on the surface, but actually very different conclusions. So what is the assessor's duty when it comes to supporting engagement? Well, before concluding a lack of capacity, the MCA requires us to take all practical steps to support the person to decide. Now, it doesn't mean forcing participation, but it does mean that we have to be thoughtful and creative. This might include adjusting the time or the setting of the assessment, changing who actually does the assessment, explaining the purpose more clearly, maybe reducing perceived threat or fear around outcomes of what's going to happen. In the case of AMDC versus AG in 2020, the court recognised that assessors don't have to rigidly push through every question if that's going to be futile or distressing. But they do need to record what was tried and why. And sometimes, as is seen in other cases, simply changing the professional involved can significantly improve engagement. But what if the person still refuses? Well, if someone continues to refuse to engage, you cannot force an assessment. But you also don't have to abandon the whole thing altogether, because the law allows capacity to be assessed using third-party accounts, historical evidence, medical records, and observed behaviour over time. So even if they don't engage, we can still use this evidence. And the question remains, on the balance of probabilities, does the person meet the criteria for this specific decision? Now, if you proceed without direct engagement, you must be able to clearly justify both your conclusions as well as any steps taken to support engagement. So, does a lack of engagement equal a lack of capacity? No, it doesn't. It may be a capacitous refusal, or it may reflect a genuine inability to engage arising from the impairment. Our job is not to assume, but to explore why. And if we can do this in a non-judgmental way, a curious way, then actually we're continuing to protect this individual's rights and freedoms and staying true to the Mental Capacity Act. So look, I hope that's been useful. I hope that's been helpful. I hope that explains and helps you understand why actually a lack of engagement does not necessarily mean a lack of mental capacity. If you have enjoyed this, please do like, subscribe and share. Please do check out some of my other videos. If you would like me to explore any specific topics or go into something in more detail, then please just leave me a little message below. I'll see what I can do. Until next time, thanks very much.